Good afternoon. My name is Nathan Hochman. I'm the Los Angeles County District Attorney. Today we will begin Assistant District Attorney Maria Ramirez. We have Deputy District Attorneys Ethan Milius and Seth Carmack. As promised, after I became District Attorney on December 3rd, we have put in the hard work to understand the Menendez case. We've reviewed over 50 defense attorneys. We've spoken to the prosecutors. We've spoken to law enforcement. We've even spoken to every Menendez family member who wanted to speak with us. So we've done the hard work to understand the Menendez case. And right now the Menendez case is on three parallel tracks. The track is a habeas track. That is a motion that was filed in May of 2023, where in that motion, the Menendezes are saying that they have effectively new evidence. And we'll get into this in more detail in a moment. New evidence that militates and warrants and justifies a new trial. The second track is a petition for clemency that the Menendezes have taken directly to Governor Newsom. Governor Newsom has the constitutional power, and it's unilateral, to grant that petition of clemency and commute the Menendezes' case and release them immediately. He has that power today. He's had that power since 2019. He can exercise it, however, he has no deadline. There's no court hearing, and there's no appeal from his exercise of that power. And the third track is a track called resentencing. Resentencing is a somewhat California notion. There's not too many states that have a resentencing statute. The resentencing gets triggered by a district attorney's motion, or in some circumstances, the motion of a court. And that motion, unlike a habeas motion, where a habeas motion will focus on the trial itself, a resentencing motion focuses on that trial but goes beyond that and deals with rehabilitation and other factors. That can be accessed at our website, which is da.lacounty.gov. Again, that's da.lacounty.gov. And that video actually does an anatomy of the Menendez case. And it takes the case from the murders itself, August 20th of 1989, through the investigation, into the charges that were filed in the arrests. Then it looks at the motions that were filed by the Menendezes prior to the trials. Then it looks at the first trial, which resulted in hung juries. Then the second trial, which resulted in convictions for first-degree murder of both Jose Menendez, the father, and a separate first-degree murder conviction for Kitty Menendez, the mother. On, though. It goes through the penalty phase, where the Menendezes were either facing the death penalty or life without the possibility of parole as determined by a jury. Then the sentencing. Then it actually goes through the various appeals, the direct appeals, all the way up to the California Supreme Court. The habeas petition, again, with the California Supreme Court. The federal habeas petitions with a U.S. District Court and a Ninth Circuit Court of Appeals. In all those situations, as you will hear, the Menendezes have raised many of the same exact arguments that they raised in the current habeas petition. Those arguments have been heard by a variety of courts, from the trial judge to the direct appeal Court of Appeals in California Supreme Court, to the California Supreme Court again, to the federal courts. They've considered these arguments, and they have been routinely and repeatedly rejected. So we have the video that is coming out and go through this procedural history so that people can actually learn from the Menendez case and help and actually educate themselves on the criminal justice system. What I've said very often is if the Menendez case is the portal by which people come into the criminal justice system and show an interest in it to find out what's happening, then hopefully they will educate them further about what happened not just in the Menendez case, but cases, criminal cases, that are occurring throughout this entire county, this state, and this country every single day. So, the video is coming out today, and it'll be out on our website. The second thing that we have done today is that we have filed an informal response in connection with the habeas motion. As I mentioned before, there are these three parallel tracks: the habeas, the clemency, the resentencing. Again, the clemency is up to the governor. Resentencing we will be dealing with in the future, in the next coming weeks, with our response. But today we have filed the informal response on the habeas petition. Now, something you need to know about a habeas petition. It's not the direct appeal. The Menendezes have already had their direct appeal through the California Court of Appeals and California Supreme Court, and they have lost. They've even had one level of California habeas, which they lost, and one level of federal habeas, which they've also lost. So now they've come back for a second California habeas petition. And in coming back for that, they have basically said there are two new pieces of evidence, along with their arguments, that justify them getting a new trial. Now, in a habeas petition, there are very rigorous requirements to actually get that new trial, which makes sense, because you've already gone through all these different layers of review. And if you've been rejected time and time again, at some point the system says that unless you have something very new and very compelling that is more likely to change the outcome of this case, then we are going to again reject your habeas petition. So when they come out in this case, they come out with two new pieces of evidence. One piece in 1988, although there's no date on the letter, in which it discusses sexual abuse that was being experienced by Erik, perpetrated against him by his father at that time. That's the one piece of evidence that they've come forward, but they also came forward with a second piece of allegedly new evidence. The second piece of new evidence was a declaration by Roy Rosello, who basically said that in the early 1980s, he had been sexually abused by Jose Menendez. But the standard to actually have a successful habeas petition requires that you meet all of the following requirements. You have to show that it's new evidence. You have to show that it's timely, that it was evidence that could not be discovered at the time of the trial, but only could be discovered after the trial. You engage in any substantial delay between the time you learned about the evidence and the time you brought your motion. The evidence has to be admissible, and the evidence has to be credible. Now, the overall argument about this new evidence, again, new evidence effectively dealing with sexual abuse that Erik Menendez experienced by his father, or a gentleman named Roy Rosello experienced by Jose Menendez, the defense has now argued the following. They've said to resolve this case, jurors had to decide a single critical question. Was Jose Menendez molesting his sons? The problem with saying that that is the critical question in the Menendez trial is that it's wrong. The jury never, in any of the two juries, had to resolve the question of whether the Menendez brothers were sexually molested. In fact, the counsel, Leslie Abrahamson, 30 years before, during these trials, properly framed where sexual abuse comes into play. What she said back then is that we have never said that because you're abused, you're justified in killing your abuser. We didn't argue that, and we never will. Well, 30 years later, apparently, the Menendez counsel is arguing just that. Because what the jury had to figure out is on the night of August 20th, 1989, conspire to kill both their father and their mother that night. Did they, in fact, kill them? And what was their state of mind at that time, on the night of August 20th, 1989? Did they engage in these killings willfully, deliberately and with premeditation, or was it an act of self-defense? They had an actual fear of imminent harm, that both their father and their mother would kill them, and they acted in self-defense. The sexual abuse part, as Leslie Abrahamson recognized correctly back then, was not a fourth question for the jury to answer. So when we look now at the factors dealing with this new evidence, we can go through these factors. Timely evidence that is discovered after the trial, for which there is no substantial delay in presenting it. Well, if this letter, supposedly dated December 1988, written by Erik Menendez to Andy Kano, is to be believed, and that it was actually sent at that time, here's what we know. We know that Erik Menendez, during his second trial, testified for 7 days about graphic descriptions of the sexual abuse that he had encountered by his father between the ages of 6 and 18. He also talked about sexual abuse that his brother Lyle had experienced by his father between the ages of 6 and 8. That evidence was brought in, and he was asked about who he spoke to about this sexual abuse during that time period. He said he had spoken to Andy Kano. When did he speak to Andy Kano? He said when he was between the ages of 12 and 13, and Andy Kano was approximately 10 years old. That was before Erik Menendez moved from New Jersey to California, roughly 6 years before these 1989 killings. So Andy Kano also testified in the trial, and Andy Kano relayed the same information, that he had had this conversation with Erik Menendez 6 years before the 1989 killings, when he was 10 and Erik Menendez was either 12 or 13. They spoke several times that year, and only conversations they had about the sexual abuse, only communications they had. So now we have a letter filed in May of 2023 that is supposedly a 1988 letter written from Erik Menendez to Andy Kano about this sexual abuse, never discussed in any of the two trials when Erik Menendez testified or Andy Kano testified. And we believe it's inconceivable, as we've argued in our papers, and defies common sense, that if they had evidence that would show that sexual abuse had been communicated not just 6 years before the events, but 9 months before the 1989 killings, that it would absolutely have come out during one or both of their testimonies. So the fact that it didn't come out, again, goes to whether or not this evidence, first, was discovered after the trial. If Erik Menendez wrote this letter, he had it, or knew about it, or Andy Kano had it, and certainly knew about it, by the time of the 1993 trials. In fact, it's a 1988 letter. They would certainly have it by the time of the 1995 trials. So to say that this letter was not discovered after the trial, as it's been alleged in the defense papers, we believe is just wrong. The second thing with this letter is that if the letter was real, then the question is, when is the substantial delay triggered in actually filing this motion? So what you find in the motion is Erik Menendez is saying, I didn't know about the letter until effectively a 2015 special by Barbara Walters, where this letter had been given to her, and she actually broadcast this letter in 2015. But remember, this motion, this habeas motion, this second habeas motion, was not brought in 2015. It wasn't brought in 2020. It was brought in 2023. So one of the additional standards for a habeas motion is that you do not engage in substantial delay in bringing this motion. Andy Kano had long since passed. He passed in 2003. So he was now around to actually cross-examine and see if this letter was an actual letter that he had received. Perhaps he received it, but he didn't receive it in 1988. He received it at some date much later than that. So This particular letter it could have been discovered prior or during the trials, and then wasn't presented. It was presented after substantial delay, even when both Lyle and Erik Menendez say that they had this letter. The third standard is admissibility. Let me deal with the Roy Rosello letter to give you an idea how the admissibility standard works. The letter has to comply with the admissibility standards of evidence in a court. Now remember, in 1989, August 20th, the issue is what is going on in Erik and Lyle's head at the time they shotgunned their parents 12 times to their death. Are they again have an actual fear of imminent harm and death, that their parents were going to kill them that night? Or was it a willful, premeditated, and deliberate act on their part? What they have said about the Roy Rosello allegations, that he was sexually abused by Jose Menendez in the early 1980s, is that they didn't know about this in 1989. They didn't know about this in 1999 or 2009. They first found out about it in 2022, or approximately 2022, about over 30 years later after the killings. So the evidence, if in fact this is true of what Roy Rosello is saying, would not be admissible to show their state of mind in 1989 because they didn't know about it in 1989. So again, it would fail the admissibility standard, as we've argued in our habeas informal response. The last standard, of course, is credibility. Is this credible? In many different ways, it is not credible evidence. The first way, as I've discussed before, is that if they had this evidence, if this letter truly existed, the defense counsel would have absolutely used it at the trial, because it would have helped corroborate both Erik Menendez's testimony about sexual abuse and Andy Cano's testimony. Roughly 8 or 9 months before the murders, not 6 years before the murders. But it was never mentioned, its contents were never mentioned, it was never produced or in any way used during either one of the two trials. But the notion that this letter could be part of a continuum of lies and deceit and fabricating stories required us to go back into the history of the Menendez. And when we analyzed that, what we found out is that Erik and Lyle Menendez had told 5 different versions of the events of what had happened. The first version that they told is that they did not kill their parents. This was the version they told when they were first confronted, or they first made their 911 call. And they said that police showed up that night. They ran out screaming and crying that their parents had been murdered. They'd come home and found them that way. They didn't admit it themselves. That they went ahead, and in that version again, they said it was a mafia hit. And they had the police investigate whether or not Jose Menendez had been killed by the mafia. That was the first version. The second version was that their father was a violent sexual predator to do so. The third version that Lyle told was that their father had molested Erik, but the mother had molested Lyle, without any mention of Lyle being molested by his father. Again, that version ultimately didn't show up a trial in their defense. The fourth version is that Erik and Lyle were both molested by their father, and the fifth version is that both their father and their mother were going to kill them the night of August 20th, 1989, which is why they shot them first. And I want to focus on the difference in many respects between the fourth and the fifth versions. Because again, the key for the trial is basically what happened that night, what was in their head that night. Sexual abuse is abhorrent, and we will prosecute sexual abuse in any form it comes. But sexual abuse in this situation, while it may have been a motivation for Erik and Lyle to do what they did, does not constitute self-defense. And that's why Leslie Abrahamson said back in 1993 that sexual abuse does not justify killing your parents, and that they would never argue that. So, what happens in the Continuum is we analyze some of the examples of the lies, differing stories that have been told, is that we actually saw stuff and this evidence ranges from everything, including days before the killings, the Menendezes didn't go ahead and get their shotguns in Los Angeles and use their real names. They drove down to San Diego and used a fake ID and a fake address of one of Lyle's friends. Hours before the murders happened, they came up with a pre-planned alibi, where they had actually gone ahead and contacted one of their friends to say that they were going to go to Batman the movie that night, and they would meet the friend afterwards at the Taste of LA event. During the murders, the way that the murders actually happened was instructive to understand the deceit and the planning that went into it. There was over 12 shotgun blasts that occurred that night. One of the shotgun blasts was to Jose Menendez through the back of his head. After he was dead, there were shotgun blasts to each one of his knees. The shotgun blast to the mom initially didn't kill her. She actually ended up lying on the ground, groaning and bleeding in pain. And that's at the point where Lyle and Erik Menendez had run out of ammunition, reload, and Lyle puts the reloaded shotgun up to his mother's face and pulls the trigger, thus staging it at the time like a gangland hit, which then becomes their deceit and lie in the ensuing months that occurred. Then you had the deception that occurred where they hid the evidence of their crime. They had the wherewithal that night been expended. They then had the shotgun shells with them. They had the bloody clothing and the shotguns. And they proceeded to go to Mulholland Drive to dump the shotguns and to a car wash's dumpster to drop off the shotgun shells and their bloody clothing. Then they decided to execute the pre-planned alibi. Again, the deliberate, premeditated state at this point where they went ahead and they actually to get the tickets for Batman the movie. Turns out that they couldn't get the 8 o'clock tickets because it was already past 10 o'clock. Then they called their friend to meet him at the Taste of LA, but by the point they got there, he'd already moved on. Then they actually called a friend to meet him again in another restaurant, and they never show up. Eventually, that friend comes to the house later that night, only to see police tape around the house. In a number of different respects. They contacted one of Lyle's girlfriends, Tracy Baker, gave her an actual script, a script that was actually found by the police, where it said that they wanted her to testify that Lyle's mother, Kitty Menendez, had poisoned them, had poisoned the whole family. But didn't testify to this in the second trial. They also contacted one of Erik's friends, Brian Eslamania, and asked him to falsely testify that Erik and Lyle Menendez were so fearful of their parents the weeks before the murders that they tried to borrow a handgun from Eslamania. He wouldn't testify to this. They also, again, as I mentioned before, asked a different the Menendezes both testified that they had gone to the Big Five Sporting Goods in Santa Monica to actually buy handguns before they switched to the shotguns. But it turns out that Big Five Sporting Goods in Santa Monica in 1989 didn't sell handguns. So we looked at, again, the credibility of the letters, and particularly this Andy Cano 1988 supposed letter, weighed it in the continuum of lies, and it calls into drastic question whether or not this is in fact a 1988 letter written by Erik Menendez to Andy Cano about this sexual abuse. But again, even if it is, it's not timely because it was not presented at the time of trial. They substantially delayed in bringing this motion from at least 2015 to 2023, and in certain respects, it's also not admissible, which is why we conclude in our informal response that the court should deny the current habeas petition by the Menendez brothers. And if the court decides not to deny it at this point, the next motion or move for the court is to order what's called an order to show cause. Then we will file this again, this response, in response to the order to show cause. The Menendezes can reply, and the court can rule at that point or have a hearing in the habeas matter. So, this is what we have been up to with respect to the habeas petition. Again, as I mentioned before, the governor has the clemency petition on his desk, and he can do weeks with the resentencing issue. Let me stop at this point and take questions, and at the end of this, I'll have Maria Ramirez address the Spanish-speaking audience on these issues. Right here.
Pushing for this. What did you tell them when you told them that you weren't going to support it?
So what I said to the family is that I would listen to them, and we did. We met with the family for hours, and I heard all the issues that they have, and all the concerns that they have, and all the experiences that they shared with me during those conversations. Much of that deals with rehabilitation. Rehabilitation is not an issue for the habeas motion. And I want to make that crystal clear, that all the talk about rehabilitation will be talk that will be focused on in the resentencing motion. But as I mentioned before, the habeas motion focuses on the evidence at trial and any new evidence that might materially affect the outcome of that trial. Yes?
It seems that your examination of case files so far has been significant. You demonstrate clear mastery of what you've seen, but it also sounds like you're casting doubt on the brothers' assertion that they were serially sexually abused by their father.
Again, what we have done is we've gone through all the evidence at the trial, which is the evidence that we have to work with. We looked at any testimony that was given by Erik and Lyle Menendez in the first trial, or just Erik Menendez in the second trial. We looked at all testimony that was given in support of the defense in either trial. We looked at any additional statements that we were given of people who had any level of percipient knowledge of the sexual abuse. We certainly looked at any other circumstance that deals with this question. And in looking at that, again, as I point out, that was the fourth version of what was told by the Menendezes in real time back in the 1990s.
So having reviewed 50,000 pages of documents, etc., do you personally now believe that they were not sexually abused by at least Jose Menendez?
What I believe is that they testified to that sexual abuse. They absolutely testified to it in great detail. I also understand that when it came to any corroborating information about that sexual abuse, it was extremely lacking. In fact, there were other, and the fact that it was their fourth version. In other words, they didn't come out initially and say, we killed our parents because our father sexually abused us. They didn't go ahead and when they got arrested, tell anyone that. They were saying it was a mafia hit and somebody else did it. They then, once they were arrested, again come out initially and say my father sexually abused me. In fact, just the opposite. They were trying to say Lyle's girlfriend was violently raped by the father. Then the next version wasn't that the father sexually abused both of them. The father sexually abused Erik, but the mother sexually abused Lyle. So then you had, as you're aware, the Dr. Oziel tapes, where they didn't believe those tapes would ever be made public. But in those tapes, where Erik had gone to Dr. Oziel because he was suicidal and he needed to tell someone that he had actually killed his parents. At no point in any of those conversations that occur in late 1989 does Erik say that he was sexually abused by his father and that was any reason or played any role in what happened. Lyle, who's also interviewed by Dr. Oziel on tape, doesn't discuss that as well. And with respect to the mother, here's what they told Dr. Oziel. They said that they had killed the mother because they didn't want her to be a witness to the crime. That was reason one. The second reason they killed the mother is they thought that she was leading such a miserable life because the dad was cheating on her that they basically thought that they were doing her a favor, which was the third reason, which is effectively a mercy killing, whereas Dr. Oziel testified euthanasia as to why they were killing the mother. At no point do they tell Dr. Oziel the father was sexually abusing them and the mother condoned it.
So just to be crystal clear, you're saying that the evidence does not exist that they were sexually abused by others?
What I'm saying is that the evidence, to the extent that evidence can include their own testimony, certainly that evidence exists. Erik Menendez testified for 7 days in the second trial in graphic detail, incident by incident, describing the sexual abuse he experienced by his father. Andy Kano talked about a conversation he had when he was 10, not when he was 16, but when he was 10, and Erik was 12 or 13, where Erik was describing that sexual abuse. So if you're asking me, was there evidence presented in the trial about it, there certainly was. If you're also asking me, has new additional evidence come out about that beyond the Andy Kano letter, there is none, or at least it certainly hasn't been discovered by the prosecution and hasn't been presented by the defense. Yes.
Have you tried to authenticate that letter?
We've asked for an original copy. The only way to truly authenticate that letter, there's only 3 ways you can do it. One, you need the original copy, or you need an envelope with a postmark. We've not been presented with the original. We've not been presented with an envelope with a postmark. 1988, and the only third person who could probably authenticate that is Andy Kano, who passed away in 2003.
District Attorney, do you believe that the Menendez brothers should be freed?
The question about whether or not the Menendez brothers should be freed will ultimately be a court question. Our job is to give the court the information, and particularly, and again, when it comes to the habeas motion, let me just start with the habeas motion, because that's what's teed up here. The Menendezes are asking for a new trial. In a habeas motion, I want to make this clear, you would not get off. You would not get released if you win the habeas motion. You would get a new trial, which is why I've gone through the trial evidence to show you where the new evidence overlaps with what all the voluminous trial. With respect to the habeas, you would not get freed in any event, even if you won. And as I said, with respect to this habeas, we believe it should be denied.
Have you just laid out a case, though, that Governor Newsom at least should think twice before he would even consider granting clemency?
I hope what Governor Newsom will do is what we have done. Certainly, we will, if he doesn't already have the 50,000 plus pages of trial transcripts, we'll make that available to him. I hope he speaks to prosecutors, defense attorneys, the Menendez family members. I hope he reviews all the rehabilitation records. You know, those also are voluminous, but they play in the resentencing motion. The clemency power he has is vast. It's unilateral. He can do it literally today. He could do it tomorrow if he chooses. He could also do nothing. Now, one example, well, that is the power that he has with respect to it. And as I pointed out as well, and this is an interesting aspect on that for a moment. what you'll have is that there'll be a resentencing hearing at some point. The judge makes the final call there. The judge can keep the sentence as life without the possibility of parole, or he can change the sentence to life with the possibility of parole. Let me play that out for you for one moment. If the judge, not the prosecutor, not myself, but the judge makes the hearing, then what will happen is it'll go to the parole board. That's the next stop in the chain of events. The parole board will then have a parole hearing at which Erik and Lyle Menendez will present the reasons why they should get parole. The parole board itself can make one of two choices. It can recommend the granting of parole, or it can recommend denying parole. And then guess who gets the case at that point? The governor. The governor then has 120 days to do one of three things. He can affirm that grant of parole, and they would be released. He can he can modify, or he can actually reverse the grant of parole, and then they will not be released. And there's no appeal at that point. Now, as an example of where the governor has exercised the power to reverse the parole board, I point you to the case of Sirhan Sirhan. Sirhan Sirhan was the assassin of Senator Robert F. Kennedy back in 1968 in Los Angeles. He was originally given the death penalty, but the Supreme Court overturned the death penalty, so he got a life with the possibility of parole sentence. For 40 years and 15 parole hearings, Sirhan Sirhan had his parole turned down by the parole board. But on the 16th hearing in 2021, the parole board for the first time went ahead and granted parole. Then it went to Governor Newsom's desk. He looked at the fact that Sirhan Sirhan had been in jail or prison for over 50 years. He was in his late 70s. He was in diminishing health. But Sirhan Sirhan had never fully accepted responsibility for the actions that he engaged in. So the governor determined him to be a danger, notwithstanding all other factors, and actually reversed the parole grant for Sirhan Sirhan, who remains in bars today. Yes, right here.
It would seem, just sort of big picture, hearing everything you're laying out right now, it would seem like you are leaning towards not recommending they should be resentenced. Is that fair to say?
So with respect to resentencing, we have not finalized where we're going to end up because it's not just the trial analysis. It requires an additional substantial analysis on the rehabilitation factors and other factors that are very unique to the resentencing statute. We estimate within the next 2.5 weeks, we'll be filing something at that point, and then we'll make our position very clear. Let me take one in the back. Hold on one sec. Let me take one in the back.
The Cano letter is not admissible, and the Rosello declaration is not admissible under the habeas structure. Is that right?
So the Cano letter actually would not be timely because we believe, for as far as Erik Menendez is concerned, it's a letter that wouldn't be discovered after trial since he wrote it in December of 1988 and the trials were in 93, 95, and 96. As for Lyle Menendez, it would not be admissible because, again, it's an out-of-court statement not dealing with Lyle's situation but dealing with Erik's situation. For the Roy Rosello declaration, we're saying that is inadmissible because a declaration about incidents that occurred between Roy Rosello and Jose Menendez in the 1980s that the Menendez brothers didn't know about to the 2020s, we don't believe could influence their state of mind when they actually killed their parents. So it couldn't play a role in self-defense or premeditated murder. Yes? So yes, we'll certainly look at many of the much of the evidence that we've discussed today as it pertains to the trial. But the resentencing motion goes beyond that. It really focuses as well on rehabilitation. It focuses on other factors that are identified in the resentencing statute. And that requires this additional analysis, which we are in the process of engaging in, and then we will finalize our position within the next 2 to 2.5 weeks. Yes, right next to you. Hold on one sec. as a starting point, as well as the voluminous exhibits we include with it, including a lot of the trial transcripts, so that he can review for himself what went on at the trial. We will also, when it comes time for resentencing, deal with the rehabilitation aspect. To add to his database of how he wants to make his decision. But ultimately, the governor, again, he has absolutely unilateral, full power, constitutional power to commute that sentence. He can, and again, you might have the issue coming up on a parole issue if it comes through that path. A question over here.
So when it comes to rehabilitation and resentencing, Lyle and Erik just did a podcast. They came on, and it's two angry men. I don't know if you had a chance to hear it, but essentially they talk about their whole rehabilitation process that they've been through, all the work that they're doing with people, all the brutalization that they face behind bars, and I wonder what your thoughts are about that, because I know you've been looking into it.
So part of a good amount of the rehabilitation evidence was in the original resentencing motion filed by the prior district attorney. And you can go, it goes on for tens of pages, detailing the rehabilitation that both Erik and Lyle Menendez have done over the last 30 plus years while in prison. To the extent, I don't know if they said anything, I have not viewed this podcast beyond what's already in the prison records that are very in the prison. But again, to the extent that they want to supplement any information that the court's going to have, I'm sure through their counsel they'll do that.
And do you believe that they've been rehabilitated based on all you looked? Again, in our resentencing position, we will deal with the full scope of our thoughts dealing with rehabilitation in the context of resentencing, because that's what's important. The resentencing statute focuses certainly on rehabilitation, but other factors, and we will make our position known like we've done it here today in the habeas position when we file our papers. Let me take another question back there.
There are many Menendez supporters all over the world who believe that they were sexually molested, and they say they've served more than 30 years. Isn't that enough? They'll obviously be very disappointed after this news conference. What would you like to say?
So what I would say again is that there are three different paths right now. This particular path of habeas is a very specific path with very rigorous standards on how you get a new trial. Again, even if they won the habeas motion, they would not get out. They would just get a new trial. And we've gone through it fairly methodically in this press conference, and even more methodically in the informal response we submitted today to explain why we do not believe under these rigorous standards they qualify to get a new trial. Again, much of what they are arguing in this second habeas petition has been already brought to a trial judge who's rejected it, the direct appeal, which is the California Court of Appeal and the California Supreme Court, which has rejected it, back to the California Supreme Court with the first habeas petition, then over to the U.S. District Court and the Ninth Circuit Court of Appeals, rejected. So most of the arguments they brought in, other than those two new pieces of evidence, have been rejected. That has heard them. So again, with respect to the habeas petition, I don't know if people understood what was involved with the habeas petition and how very specific and narrow it is, but that's why I've done my best, both in this press conference and in the video that we've put out, to explain how these processes work. Yes, over here.
The previous district attorney wrote letters to Governor Gavin Newsom in support of the brothers' bid for clemency. Would you do the same?
I'll let our filings speak for themselves. So if the governor, and I'm sure that if the governor wants to get a hold of my informal response today, if he wants to get a hold of any pleadings we file in the resentencing case going forward, if he calls me up, I'll be happy to send to him, but they're available publicly. And in fact, we'll put them on our website, da.lacounty.gov, and the governor can access them there.
Have you made a decision yet, even if you're not telling the press?
We have not made a decision on
of not just analyzing the trial evidence, but analyzing the rehabilitation and all the other evidence that's required in a resentencing motion.
District Attorney, you haven't spoken to the brothers yet, and we know you don't have to. Would you like to?
Again, it's not, the defense counsel has never offered to make the brothers available for me to speak with personally. Whether I speak with them or not, starting with the habeas petition, is irrelevant. Because again, what this focuses on is a very narrow legal standard on whether or not the new evidence, these two new pieces of evidence, meet all those standards I've gone through, warranting a new trial. With the resentencing, again, the Menendezes have put letters already that they have written in connection with the resentencing. We've read those letters. We will be considering those letters as well as all information that the defense has provided. I don't believe speaking with the Menendezes one way or the other would influence what I ultimately come down and do. The record is very voluminous and I believe very complete. Next to yourself.
Do you believe, times have changed and maybe now we have a better understanding of what it's like to process childhood sexual abuse? Looking back.
I mean, I think that we've certainly, our abilities to understand it over the last 30 years have certainly improved. But the question back, and this is why I focus on what Leslie Abrahamson said about the role that sexual abuse played at the trial. That she said, sexual abuse does not justify killing your parents. It doesn't that day, and it never will. And that's what I want to make crystal clear. That came from Erik Menendez's counsel in 1993. And so, again, whether or not sexual abuse understandings has no bearing. Yes?
So, in terms of your doubts regarding the sexual abuse defense, just how much will that factor into the resentencing decision, whether or not the brothers were sexually abused?
Again, everything I've said today will certainly be part of what we consider in dealing with the resentencing motion, but we're going to go well beyond this. Today's focus has been on the trial and the evidence presented going over the next 35 years beyond that. Let me take one more question.
Sir, any feelings about
Actually, in the corner there.
In meeting with the Menendez relatives, what are your thoughts on what they've had to tell you? And have you also met with Milton Anderson, his brother?
So my thoughts about, again, the meetings that I had with the Menendez family members, it lasted approximately 3 hours. I then thereafter had a phone call with Milton Anderson. I had never spoken to him personally until that phone call. Had that phone call, I invited him to say whatever he wanted to say, and he did. That forms part of the compendium of evidence that we will consider in the resentencing motion. It actually does not affect one way or the other the habeas petition that we have filed our informal response today. All right. Thank you all very, very much. I very much appreciate it.